What's up, family? All right, so I'm trying something new. Y'all know I'm always trying something new. And I can tell it's a little wonky. Can you guys hear me? So I'm using StreamYard today. And StreamYard is supposed to allow me, hey, Lady T, I can see some of y'all. I can see some people in here. I'm trying to see how the chat function is working. I am simulcasting from both to both YouTube and Facebook. So I'm hoping that this is gonna work. Y'all know I'm always trying something, trying. So finally, I was gonna do a live last night, but I got stuck on a podcast. I don't know if you guys know about the Home podcast, Home of Melanated Excellence. Y'all see my green screen is half. Need to be pulled over, whatever. You know how it goes. I'm bootleg when it comes to this stuff. Y'all want to help me? Just let me know. All right, so we're gonna be talking about the Chauvin trial. Thank you, keeping busy. Hey, Cassandra. So you on Facebook, Storm Vet. I see you on YouTube. That's cool. So this is all new and exciting for me, being able to reach multiple platforms, because I'm always trying to make sure that I'm talking to as many people as I can. All right, so we got a recap from last week and then catch up to today. So there's a little delay, so I'm trying not to look at myself too much because it's driving me crazy. And I got a new internet, I got new Wi-Fi, I got a new router and all that good stuff, but it's still acting up. Let me put my phone on vibrate. Oh, and so if you want to join me, I can have guests in here. If you want to join me, let me know. Thank you, Phoenix Sun. Thanks, Rob. If you want to join me, let me know, because I think I know how to do that. I think I know how to do that. I'm working on it. I'm working on it. All right. For those of you who follow me, know I'm back in the gym. I'm back in the gym. Training with Max the Destroyer, and he is destroying me like it's his job. But you know, that's what I paid for. All right, so I got some notes from last week, so let's get into it. Hey, Aaron, how are you? Or is it Aaron? I do this every time you come on, right? I'm like, is it Aaron or is it Aaron? Let me get my notes together. Let me get my notes out. All right, okay. So the way I'm watching this trial, right? I'm looking at the prosecution because, right, we're in the prosecution's case, right? This is the prosecution's case in chief, where they are going to present all of the evidence that they think is enough to convict Chauvin and find him guilty of the charges. Now, just to review, quick recap, he's charged with murder in the 2nd degree, and I hear my dog barking. Murder in the 3rd degree and manslaughter in the 2nd degree. And somebody needs to do something with that dog. I know they hear this. Y'all, do y'all do this? You have to text people in your own house because they act like they don't hear stuff that's going on in the house, right? Like y'all hear that. I know you hear him. I know you hear him barking. Oh God, I'm gonna text one of these children of mine. They probably sleep. Of course, my phone on. Get the dog. Jesus. OMG. Don't laugh at me, Storm Vet. Hey, Brian Smith. What's good with y'all? Y'all hear the dog, right? I'm not going to get him. All right. So last week we had all the emotional testimony. I was talking about how to characterize this trial, right? Last week was just raw emotion. Wasn't a lot of what I think as an attorney substantive evidence, right? And this week we got it's like the parade of the cops. Parade of the cops. So let's recap last week. Last week we saw some interesting testimony. We saw We saw a testimony of Donald Williams. Remember Donald Williams? He was the MMA fighter who happened to be on the scene. He testified about seeing Derek Chauvin's knee on the neck and making a comment about it being a blood choke and things of that nature. That's really, I can't, he's going to drive me crazy. So I got to be right back because nobody's listening. Nobody cares. I'll be back. Can somebody get the dog? If I keep off one more time, I'm putting you in the shelter. I'm not serious. I'm not gonna put my dog in the shelter, y'all. All right. So Donald Williams' testimony. I feel like I talked about this a little bit already. He was a little bit combative on cross. I don't know if you guys remember that. Jurors don't tend to like that. He was a little combative on cross. And what he did testify that I thought was helpful for the defense is that he testified that an unconscious person can get up and start fighting again. Right. So that's going to go to the defense is going to use that as why Chauvin stayed on his neck for so long. Right. We also heard from a couple of child witnesses. Right. There was one child witness, and I was in my head. I was like, why do they have a child witness? I later learned that in Minnesota, there is a sentence enhancement if a crime is committed in front of a child. And so that's one of the elements that the prosecution has to prove. So they had to put the child witness on to say what they had saw. I thought it was just overkill, but it actually had some purpose. Okay, so then they have this thing in Minnesota, which they don't really have here in New York, where I'm an attorney. It's called Spark of Life testimony. Spark of Life testimony is when a family member typically gets to come in and tell the jury about the victim, right? Who he was, what this has done to them, right? Typically that's not permitted, but it's permitted here in Minnesota. So the girlfriend, her name is Courtney Ross. She came and she testified about how she met George Floyd, and they fell in love and had children, or I think they have a daughter. But on cross, she said some things that was again helpful for the defense, things that we had not known before. Now I don't know if you guys saw this testimony. No, you didn't threaten to evict the dog. I got two, so if I gotta get rid of one, no, I'm kidding. I'm kidding. I am kidding. I promise. They're brothers. I can't separate them anyway. I can't. That would be just cruel. And so I gotta keep them together. They my babies, my other babies, my fur babies. So the girlfriend, Courtney Ross, testified, and she told us something that we did not know. That back in March of 2020, remember this happened May 25th, 2020. 3 months prior, March 2020, George Floyd had to go to the hospital because he was experiencing an overdose. So she came and she testified that she went to pick him up for work and he was having severe stomach pains. Did anybody see this testimony? And she said that she took him right to the hospital. And at that time, she talked about where they would get drugs from. Now, typically, if you're using pills, sometimes you get them legitimately from people who have prescriptions who are selling their prescription, right? So this is medical grade. But there are other times where you cop from somebody from the street, you have no idea where these pills came from, right? So she testified that the two people they were with, that George Floyd was with that day, Shawanda, what's her name? Shawanda Hill and Maurice Hill, something like that. Hill and Bill, they got rhyming last names. Anyway, that they were the ones who had on previous occasions sold them pills that she said made her feel a little funny. Right. And on further cross-examination, she talked about how the pills made her feel jittery, and how she didn't like them. And that those pills she believed may have come from either Shawanda or from Maurice. Now, I don't know if you've been following, but Maurice is apparently in jail on a domestic violence case, something to that effect. And he has sent a motion to quash his subpoena. via his public defender to the court, basically saying, if you subpoena me and I have to come to court, I'm going to plead the fifth, right? And so they're going to take that up tomorrow morning, and how the court is going to deal with him, because there are some things that the prosecution can do if they want to compel his testimony, right? If someone is saying, I'm not coming to court because there is the threat that you might charge me with a crime if I testify, how do you resolve that? Give you immunity. I give you immunity, right? So if the prosecutor says, oh, I'll give you immunity, you got transactional immunity. Anything you say regarding this incident and the drugs and all of that, we won't charge you for none of that. Don't even worry about it. They could do that. And then he can't say, I'm taking the fifth. He can't plead the fifth at that point, right? So we'll see how the prosecution handles it, or if they just let him decide that he's not going to testify. I watched her testify and wondered why on earth the prosecution called her. I thought the same thing, Storm, like, did they really think she was going to be helpful? Because she knows all the history of his drug use. And the defense is like, right. And so fentanyl, he was using fentanyl at that time. Those pills, did they look like Percocet? Right. So the defense is lining it up to say that the pills, those funny pills she had before, those are the pills he had this time. And not only those are the pills he had this time, those are the same people he got those funny pills from on scene. Right. So he's laying the groundwork to, stitch all of this up by the time summation comes. So, yeah, so that was the girlfriend's testimony. All right. Then we also had a cop come in who gave some body camera. Well, he was the custodian of the body camera, right? So he wasn't a fact witness, but he came in so that he could lay the proper foundation so that the prosecution could get in all the body cam videos from all of the police officers, right? And so in putting those in, he played them all. Part of that problem with that is that you give the juries get sort of fatigued, right? And then the impact that you hope this video will have, it starts to get diminished every time you play it. They get a little less sensitized to it, right? And so you've played it 100 times in this month period. By the time they get to the jury room, it won't have any impact on them, right? So that's a danger that the prosecution was treading on last week. Dogs. That's just part of my life. That's just going to always be part of my life. Just to deal with it. Okay. We had some paramedics come testify last week also. I hate this iPhone. Shawanda Hill and Maurice Hall. That's the names. I got it right here in my hand. Oh, and that when he did overdose back in March, he stayed in the hospital for 5 days. 5 days. 5 days. And again, the stomach hurt. He said the same thing when he was being arrested in May. He was complaining that his stomach was hurting. He was foaming from his mouth in March. He was foaming from his mouth in May. We also learned that in his phone that the girlfriend is saved as Mama. Did you guys learn that? Was that surprising to you? Because the defense is, trying to mitigate the whole, he was calling for his mama, his mother, his real mother, right? And really, in fact, he was calling for his girlfriend, maybe, right? Because his mother, I think, passed in 2018, even though he, one of the things he said to the officer, listen, I just lost my mother, right? Which is something that the defense brought out today with a number of witnesses saying that, isn't it true that people will say certain things to you just to keep you from arresting them? Excuse me. Ooh, sneeze. I got the window open just in case, I've been doing good with my hot flashing. But just in case one come, I got the window open. Okay, so then we have the paramedic come on. I'm checking the yeah. I'm gonna talk about that in a second, Winter, because he really didn't say that. See that's he didn't say that. That's not what he really said. He really didn't say anything, honestly. And some of what he said was more helpful for the defense. But I don't want to skip around. I want to make sure I get all of this out. The paramedic came and he testified that there was no pulse. George Floyd did not have a pulse upon arrival. That's a big factor. right? Because the police officers who were on him should have known that. And if they knew that, then they should have rendered aid, right? And so why wouldn't they know that someone that they have in custody has lost consciousness and now doesn't have a pulse? So that was kind of important. The other thing that the defense brought out was that when the paramedic did come, he was able to check his pulse even with Derek Chauvin's knee on his neck, back. And that was interesting today, what came out today. We're going to get to it. Okay. What else? The EMT has seen police on top of a suspect before. Someone overdosing can become violent and aggressive. He was able to check the pulse and reach the pulse while Chauvin was on his neck, which implies that maybe Chauvin was not applying pressure. Then we had the Lieutenant Zimmerman. He's a very elderly, like one of the most senior officers on the police department. He hasn't been on the street in 20, 30 years, but he basically said that they should have gotten off of him once he was fully subdued, and that to stay on him was unreasonable, right? The judge did not allow him to say much more than that. He wouldn't allow him to give any expert testimony the way he allowed the witnesses that came in today. All right, so let's talk about a little bit of today. I'm going to be moving around. There was also last week the young girl Daniela. She testified and made everybody cry. This is the one who testified about, her brother and her father and all of the other black men in her life, and how she can't sleep because she apologizes to George Floyd that she couldn't do more. That was powerful. And the testimony of Charles McMillan, who was the older black man who was on the street telling him, "You can't win, man, you can't win." Him breaking down in court was a powerful moment as well. But again, last week was all emotion, right? It was all emotion. And this week is all about the use of force. So let's talk about this week, right? So before we talk about the use of force, we'll talk about the doctor, right? So Winter, you said the doctor, this is Dr. Bradford Langenfeld. Bradford Langenfeld. So the problem I have with this doctor, this witness, is that he was not informed that George Floyd had been acting erratically. He wasn't informed that he had symptoms of drug overdose. He was not informed that they suspected that he might be on drugs, because the cops said he was on something. That was never communicated. It either wasn't communicated to the paramedics, or the paramedics didn't communicate it to the doctors. The paramedics did not administer Narcan. We learned that today. And we also learned that the doctors did not administer Narcan. So all of his assumptions were based on the very little bit of information he had, right? And so that sort of takes away from the validity of his opinion, because he's not fully informed, right? So that's kind of what my issue was with him. I think the prosecution was trying to push him into saying things he was not comfortable saying. And so he said things like, it is possible and it's likely, right, that he died of asphyxiation. But he didn't say that it was a substantial causing factor. And that's what it needs to be, right? It needs to be. And you have to have that the asphyxiation is attributable to the actions of George Floyd. It can't be that there was asphyxiation as a result of the depression of your respiratory system, as a result of you having used fentanyl and methamphetamines. On cross-examination, the defense attorney got the doctor to admit that if you are taking copious amounts of fentanyl, it does make you sleepy. We know he's going to tie that up with the testimony from Shawanda, who said the reason she had to call for a ride is because George Floyd kept falling asleep. I love you too, Phelan Roger. I heard that, but he was calling for his mom's. I don't know. How do we know? The paramedics didn't see any sign of that. But so, and that's another thing, that the failure in the communication at that point, like there should have been some communication. Well, I want to know that too, Keisha. Why? I mean, there's this narrative that they worked at the same club as bouncers, right? As the security, and that they knew each other. They even have like an interview of one of the managers slash owners who says that, they both worked at the place and they probably knew each other, but they can't prove it, right? So I don't know why that's not coming in. Um, it's odd to me. There are a few things that I don't know why they're not calling Dr. Bodden, who did the second autopsy and found that there was in fact evidence of asphyxiation, that there was in fact evidence of hemorrhaging in his neck, which the first autopsy didn't find. They're not calling him, right? So when people ask me, why are you thinking they throwing the case? Mm, that's why. That's why. Because that doesn't make sense to me. Hello, Victoria from Savannah, Georgia. Okay, so that's the doctor. He also testified. I think I said this already, that he testified on cross that fentanyl will make you sleepy. So that's part of what the defense is trying to line up. Then they had a number of police chiefs come in. You had police chief Eamon Mo Yeldon. Don't get me. I probably spelled that. I said that all wrong. And then there was another police chief, Arredondo. Arredondo. So they're all specialists in the training and use of force for the Minnesota Police Department. And they basically came in and talked about what the training consisted of. And they basically said that what was happening with Derek Chauvin was a violation of their training policy, right? On cross-examination, it did come out that they did have a maximum use of force policy, which allowed you to restrain somebody by the neck. So that came out, right? So it'd be interesting to see how the jury handles that testimony, because even if it was a violation of force, it still has to be the causation. And we haven't gotten to causation. We haven't gotten to the experts that are going to come in and talk about the cause of death, right? We haven't gotten to that yet. All right, so that's kind of where we are. One big thing that happened today in trial that I left my mouth like, oh. The defense brought up this idea of camera angle bias. Camera angle bias. And he brought this up with the black chief, whose name I can't pronounce, right? And he showed him two pieces of footage. It's the same time frame taken from two different angles. The first angle, he asked him, this appears to show Derek Chauvin with his knee on George Floyd's neck, correct? He said yes. And then he said, now this is a photo, exact same time from a different angle. This appears to show Derek Chauvin's knee on George Floyd's back. And he said yes. He said yes. That's powerful, because what the defense is arguing is that the tape really doesn't tell the tale, right? Everybody's like, we saw it. But did you really see it? Right? Because if this camera angle bias obviously is a real thing, because he got the detective to admit that in the very same frames, looking at the same thing from a different angle, you're going to have a different perspective, right? And so most of the footage that we see from the street, or whether we're looking from the bystander video, is from the angle that appears to show Chauvin on his neck. But the body camera footage appears to show him on his back. I'm really getting aggravated with the prosecutor. It's like he's doing enough to not be side-eyed by not fighting and all that war. Yeah. Right. And that's what they do. They walk a really thin line to make it look like they're going hard. But in reality, they're not. They're not. Like he makes. There was a question on cross to the doctor. The defense attorney asked him, do you know whether or not people ingest narcotics rectally? right? What they call that, boofing, right? Because it absorbs in your bloodstream faster, you get higher faster, blah blah blah. He just asked him that. On redirect, Blackwell gets up and he's like, "Was there any evidence that George Floyd put drugs in his rectal area?" And the doctor's like, "I don't have any evidence of that." It's like, well, why you let him beat you into that? We know it's no evidence of that. Why even ask that question? What are you doing? Are you trying to look like you are fighting the good fight? Because that's what it looks like to me. That's what it looks like to me. So, but yeah, that's interesting. So my question to you guys, let me ask y'all something. Do y'all think do y'all think that um the DMX drug overdose might factor into the minds of some jurors when considering what happens when someone suffers from a drug overdose? So the reports are that DMX suffered from a drug overdose that triggered a heart attack. And now I think I read that for about 30 minutes that he was deprived of oxygen, right? And it could be because he had a heart attack. Your heart stops and your system shuts down and you stop breathing. And as a result of that, now that he very well may be brain dead. That is eerily similar to what the defense is saying happened to George Floyd, that he had an overdose that triggered a heart attack that caused his whole body to shut down, which caused him the deprivation of oxygen that resulted in his death. What do you think about that? The DMX case shouldn't play a role, right? But you can. These jurors are not sequestered, so they know what the news are. They're allowed to look at the news, right? He just need. Yeah, you're right, Storm. You only need reasonable doubt in one juror who has to say that camera angle bias thing. I didn't see what they think. What the prosecution is selling. Because from the body camera footage, that very same angle shows the knee on the back, and that would support the medical examiner not finding any evidence of asphyxiation in the neck. No bruising, no hemorrhaging, nothing like that. No contusions, not on the outside of the skin, not on the inside of the skin when they pulled the skin back from his neck. So, that's the thing about jurors. You never know what they're thinking. And trying to figure that out is like reading tea leaves, right? Because all manner of things they become privy to, and it may affect how they view the evidence. All right, let's see. Let me get to the comments. The jury shouldn't be watching the news, correct? No, the jury can watch the news. Won't it taint their verdict? They can watch the news. They can't like post anything on social media and things like that, but they certainly can watch the news. I would have to say the defense would have to prove that George would have died from the OD. Yeah, see that's not how the system works though, Jason, right? It doesn't work that way. The defense doesn't have to prove anything. The prosecution has to prove that he died from something other than an overdose. They have to prove causation. They have to prove that it was Derek Chauvin's knee that is the substantial causing factor of the death. The defense attorney would have to make the DMX correlation, but no reason. No, the defense attorney doesn't have to make it. That could come out in conversation and deliberations, right? Nobody is a tabula rasa, right? Which is a blank slate. We all come into every experience with our own biases and our own information and our own knowledge of things. You don't shed those things when you go into the jury room, right? And so even if it's not a DMX thing, if you are a person like myself who grew up with a heroin addict in the home, and you witnessed someone overdosing and you know what that's like, you're going to bring that with you into the jury room. When you're considering the evidence, when you have to assess credibility. You're using your life experiences to determine whether or not someone is telling you the truth. There is no barometer in the courtroom, a truth meter that you can look at and say, oh, the meter's going up, they must be telling the truth. That's not how it works. So hold on, I'm gonna try to get back to, I'm losing some of the comments because I definitely don't want to make the video too long, because I'm really hoping to do to come on here now that I see the stream working, even though it's a little behind. It could be because my son is on a game. You know, he got that PS5. Let's see. I have to make the DMX correlation. Okay, you're a deep thinker. Most people don't make correlations like that. That's true. Hopefully they're not watching my videos. All of this could have maybe is a pain. Yeah, well, that's what the standard is. We all know the knee on the neck could have killed him with no drugs in his system. Could have. Do you want to go to jail? If someone said you could have killed someone, you want to do 25 on a you could have? That's not the standard. Not for nobody, not even people we despise. And trust me, I want them to go down just like the next person, but I'm a criminal defense attorney. And I know that is a very slippery slope. So I want him to get a fair trial, just like I want the rest of my clients to get a fair trial. Understand where I'm saying, where I'm coming from? All right, let me go down now. Apparently, I could show some of these comments. I like that. Plus, DMX isn't dead. No autopsy on him. He's not dead, but he is in a vegetative state due to lack of oxygen deprivation from a heart attack that was triggered by an overdose. Right? So there's that fact alone for the jurors. It's enough to say, okay, that can happen. That can happen. Let me tell you, if you had a 200-pound man lean on your chest back area, you're going to have a hard time breathing. That's possibly true, but you know, he's going to argue, I wasn't putting any pressure. Wasn't putting any pressure. That's another thing, right? Because people are, it appeared that he was putting his pressure on the knee. Even one of the sergeants testified, it appeared from George Floyd's reaction that he was putting a lot of pressure on. But again, if we're going to go with that camera perspective bias, there's no way of knowing. No way of knowing. Oh, yes, the book up there in the corner, Black Girl Slim. Yes, that is on Amazon. That's on Amazon. G Light, hey, sis, I came late. That's all right. You can rewind. Faith, I just want to know one thing. Let's see. Let me see if I can show a comment. Here we go. Faith. Look at me, y'all. I'm all technical and stuff. I just want to know one thing. When the officer said he had no pulse, why didn't he help him? Yeah, I want to know that too. I want to know that too. There's a lot of things that I want to know, you know, but that's the thing about the vacuum that is the courtroom. The vacuum that is the courtroom is that you don't always get to know every detail, and you still have to try somehow to figure out what the facts are based on the evidence you do have. And remember, the only way we could know that is if Derek Chauvin is to testify. And I'm gonna bet money that he won't. I don't think he's going to testify. One, that's going to open the door to all his prior complaints and his prior background, and it's better for them to not know that, right? So that's the only way we get to know. And if he doesn't testify, we may never know that. And they can't speculate, and they can't draw a negative inference, right? They can't draw a negative inference. Oh, you didn't testify, so you got something to hide. They can't say that. They can't say, oh, you didn't testify because you don't have an explanation for why you did what you did. So, all right, let's see. people go to jail over could have as bias. We need an attempted at least. See, that's the thing. He's not charged with attempted. Now, at the conclusion of the trial, it could be that the defense moves to have what's called a lesser included added, right? And it would be up to the judge to decide whether or not the evidence bore out an attempt. But that's another thing, right? Sometimes prosecutors often overcharge. I think their best shot here is the third degree. The third degree. Oh, real dude up rising. He told me what ex parte meant. I love that. Will cops testify against him? They are. The cops testifying against him. It's helpful when it comes to the question of use of force, right? And so they have to determine whether or not he was engaged in excessive force. That goes to one of the charges. They have to determine whether or not Derek Chauvin was committing an assault. If he was committing an assault at that time, that lends itself to the second degree murder charge, right? And so if they can show that the excessive use of force is the equivalent to an assault, then that testimony will be helpful. The problem is that testimony, it gets neutralized on cross-examination, right? It gets neutralized on cross-examination because a lot of the officers, everything they say is qualified, right? The defense makes it a point when he talks about everything the officer said. This is an excessive use of force. This violates department policy. What he says is, isn't it true that when you are out there on the scene, it's constantly changing? You are constantly reevaluating your position, right? And they have to agree to that. And isn't it true that it's what's reasonable for the officer on the scene at the time? Yes. And so you sitting in the chair a year later and you haven't arrested anyone in 25 years. You really aren't the authority in what is reasonable for an officer in that situation, because you ain't been in that situation since, forever. So I don't know how much weight, right? Because this comes down to weight, and it comes, it's admissible testimony. It comes down to how much weight the jury will give it, right? And I'll be curious to see, because oftentimes when you have these experts, right, because the defense is going to have experts too when they put their case on, the experts tend to neutralize each other. They neutralize each other. And so then what does the jury do? I believe he's going to get off with a slap. So it's easier for me to show it, because then I don't have to squint. I believe he's going to get off with a slap on the wrist. The family settled out of court is to show the prosecution, please work together. Well, they do, but this is the attorney general, right? So the prosecution is not the local Hennepin County prosecutor who has to deal with the Hennepin County Police Department, right? So in that regard, this is a special prosecutor, right, who's supposed to sort of lessen this whole the conflict of interest problem. Right. Mikey said the cross-examination of the cops will kill that. And I agree with you. Oh, you over here on YouTube and Facebook. Al, Mike, you see me, kid? I'm simulcasting. Hey. I'm getting there. I'm getting my life together. Why does defense keep saying, would you agree? But when they respond, they only want yes or no. Because you can agree yes or no. So the goal of the defense is to make the witness a bobblehead doll. Right? The defense, when you ask a question, you're supposed to lead and suggest the answer. And so that's why he's doing it that way. It's not the most effective way to ask a question on cross, but everyone has their own style. I'm not a would you agree, because motherfuckers don't like to agree with people, especially when they're not your witness. Right? As soon as you say agreed, it puts them back on their heels because they don't want to agree with you. Right? And so it's like, and then they take extra long to answer a simple question. Like, isn't there a difference between being detained and being arrested? The defense asked that of two questions. You would agree with me that there's a difference between being detained and being arrested. And both cops were like, I guess, so yeah, I don't. But he's trying to make the witness into a bobblehead doll. So you would agree that this is the thing. Yes. You would agree that. No. And it's true that. And also, it's a fact that. So he could switch it up, but he's just not. One of the arresting officers said we should turn him over. Chauvin said, yes. So one of the arresting officers, I think it was Lane, and this was on the end of last week when the body camera footages came out. Lane basically says, I think we should turn him on his side. I'm concerned about the excited delirium. right? And Chauvin's response was, we're holding for EMS. EMS is on the way. And so you hear a lot about that in the testimony with the police officers about holding for EMS. Isn't it a policy to hold for EMS, right? And so that came out, yes, it's a policy to hold for EMS, but then it also came out that even while you're holding for EMS, it doesn't preclude you from rendering aid, right? So that's how that came out. You know what that led me to, right, as a former prosecutor, is that there is a police officer who had to be aware that this man was in distress enough to say, let's turn him to his side. And I said this before, and this is another reason why I think that the prosecution is bullshit. You could have used that police officer as a witness instead of charging him as a defendant, right? You could have did the same thing, give him a subpoena, give him immunity, get him to come in here and testify. You said that, and he doesn't, it's not like he's betraying the badge. It's on video and audio. We heard you. You said this. When you said this, what were you thinking? What were you seeing? Right? And so I don't know why the prosecution is not using that and making more of it, right? Because if we're going into the mind of a person and we're trying to show, the only way we can figure out what somebody is thinking is by what they do, right? And so if one officer has a perception, it is not a stretch for you to argue that fellow officers in the same and similar circumstance should have the same perception. I don't know why they're not doing that. Good question. I missed the question. Hold on, let me go up. Did I miss a good question? I'm trying to get them, y'all. Monique Daniels, you're welcome for the live. Sis, I said check your email. I sent you an email today too. Mikey, I hope everybody's been managing their expectations too. I appreciate you. If I missed the comment, it's because I'm slow. I'm coming. Let me come down. Why did the prosecutors only show the still pictures of the EMT footage? So again, it could be out of concern that they had already shown the jury this footage over and over and over and over. I mean, every single witness that had come before now EMT, we talking EMT or paramedics? Because remember, the EMT chick, I'm gonna say chick, woman, was the woman who was a bystander at the time, who was in plain clothes and identified herself as an EMT for a firefighter. But so to answer your question, it could be that they just don't want to desensitize the jury too much, because it can be overkill, right? And give them a break on the emotionality. Yeah, I think I made that word up, but I don't care. Could be that. I did see a commentary on that. Did you think it was interesting that she showed up to testify in her firefighter uniform? I mean, as a defense attorney, I would object to that. You're not here in your official capacity. You're not here to testify in your official capacity. Go put on civilian clothes. You're a civilian. You're testifying as a civilian, because I don't want the jury to give your testimony more weight than it deserves. But I don't know if the defense made any argument about that. Perry Mercer will put Chauvin away for a long time. I would put Chauvin away for a long time. Believe that. Yeah, I would have loved to be the prosecution. I actually told someone the other day that I would not be opposed to lending myself out as a special prosecutor in cop shooting cases. Now I hate the prosecutors. I went up. Listen, it's going to be interesting to see what happens. We're almost past this use of force. I really don't think the prosecution has a lot more in terms of evidence. They've got to do causation, so they're going to have some medical expert. I don't know. They're probably calling their medical examiner the first one, because if they don't, it's going to look like they're hiding something. His report is very damning to them, and so they're going to have to call someone else behind him, which is going to make them look crazy, right? Because the defense on open said that they basically were expert shopping, right? You were expert shopping because the expert that you had, the one that works for the county, didn't say what you wanted, right? They didn't. His report and his finding was not consistent with how you want to sell this story to the jury. So it's going to be interesting how that testimony comes in. But then I think that's really it for the prosecution. And I don't think they have much more than that. And then they're going to rest, and then the defense is going to start their case, right? And they're probably going to have just the experts on use of force and experts on causation, right? So they might have maybe a week, and then we should have a jury case going to a jury. So that'll be interesting. Cops should be required to take the stand and explain their actions. Well, cops don't lose their Fifth Amendment rights either just because they become police officers, right? So you don't shed your constitutional rights because you took this job. So I don't know that I could agree with that, L. Summers. I don't know. Yeah, I talked a little bit about that, G. What about his friend that's taking the fifth, but two black girls can get up there and be traumatized again, right? And that's the point, right? Because the prosecution didn't have any qualms about putting these young people on the stand, 17, 18, 12, old man, paramedic, like all of these bystanders they got to testify. It was cumulative. They all basically said the same thing. I was traumatized by what I saw, and I told him to get off the neck, and he didn't listen, blah, blah, blah. They all said the same thing. Why can't they make sure that they get this guy in? Because they don't want him to testify about the drugs that he sold or was selling to George Floyd, because then he would have to tell the truth, right? He would have to tell, he would have to tell the truth about his selling, what he was selling, when he sold it. And the defense is going to ask about March. You sold him the pills in March. Those were the same pills he was having an overdose reaction to. Same thing. And there is a photo when Officer Lane opens the door, George Floyd's mouth is open. There's a pill in his mouth, right? So there's also that argument that there's the picture of him in the store. I don't know if y'all saw them. You remember Jungle Fever, right? And he was doing the dance, and I was like, he hiding a motherfucker, right? I was like, he is high. So maybe if he's already high and then he ingests because the police are there, that's the thing that sends him over, right? That's the what's too much for him to withstand. So yeah, I agree, Mona, that the prosecution needs to get Maurice Hill, give him immunity, and get his ass on the stand. But maybe they don't want him because he's going to hurt their case, right? He's going to hurt their case. He's not going to be helpful to them. So they're just going to let him go ahead and quash their subpoena. 10 years. I thought that she turned 12. All right, 10 years old, even younger. But again, they needed to put at least one minor on the stand just in case they do get a conviction. They can request a sentence enhancement because this crime happened in front of a child. In the military, you relinquish, but then you go to military court. You don't come to civilian court. It's a different process altogether in the military, right? It's a different process, and the penalties are different as well in military court. You could be court-martialed, or you could be discharged dishonorably, in anything in between there, right? Okay, yeah, he was high. He was a gator. Thank you, Daryl. Thank you. Y'all be on it. I love y'all. Y'all be on it. Y'all be on it. So we got about 10 minutes left. What else y'all want to talk about in this last 10 minutes? Because this trial is going to be going on for at least 2.5 more weeks, 3 weeks. So we'll have plenty to discuss. That camera perspective bias, keep an eye on that. Keep an eye on the camera perspective bias, because that might be a game changer. That might be a game changer. There were 4 minors, Keisha. Keisha said there were 4 minors. Yeah, I think they only need 1 for the sentence enhancement, but they didn't. Like I said, that testimony was cumulative. But, they were going for the shock and awe, because at the end of the day, if they don't have the evidence, they're hoping for, a runaway jury. They're hoping the jury will convict on sheer outrage alone, even if they don't prove their case beyond a reasonable doubt. That's what they're hoping. Well, I don't know if they're hoping that or not, or they're just hoping that it'll look like they put up a valiant effort. Let's see what they say. When a person takes a stand, do they void their right not to self-incriminate, meaning they can't plead the fifth? L. Summers. So when a person takes a stand, if there is a danger that their testimony might incriminate them, then they can plead the fifth. They can say, I refuse to answer that question on the grounds that it might implicate my Fifth Amendment right. Right? So they can do that. However, if you are a material witness, let's say you witnessed a murder, right? And you're afraid that the prosecution might charge you because you know the murderer and whatever, y'all got a relationship, y'all was together that day, whatever may have you. And you say, I'm not coming to testify about what I saw because you might try to charge me, right? I'll plead the fifth. The prosecutor can then say, I'll give you immunity. So now I'm removing the danger of you saying anything that could implicate yourself, because I'm telling you that you can't be charged for a crime regarding what your testimony is. Remember, this immunity is not for the rest of your life, meaning you can run out of here and commit all manner of crimes. No, it's only with respect to what you are going to testify about. Okay, so they could do that. You do not void your right simply by taking the stand. Let's see. Information Man Show, Peace King. Wayne Harris, how do you feel about the judge? How do you feel? Let me see. How do you feel about how the judge will charge the jury? It's interesting because typically, judges are very pro-prosecution. And it's interesting that I don't see this judge being overly pro-prosecution. And I think even the prosecutors are taken a little back by that. But I think his jury instructions will be straight up and down. And jury instructions typically are. Most states have what's called pattern jury instructions, where you literally are just pulling the elements of the crimes that are charged and you're just reading them to the jury and making sure that they understand what evidence they can consider, what is not considered evidence, and things of that nature. But I feel like he'll be fair. I feel like he'll be fair when it comes to the charge. That's the least controversial part of a trial. Most times, sometimes it can be controversial too, but most times that's the least controversial part of the trial. Sometimes that's the part where people can tone out because you've heard it 1,000 times, so you know exactly what the judge is going to say. But pay attention, because sometimes judges leave shit out on purpose. I've had that happen too. And you're like, Judge, I didn't hear you say the part about. And I had one judge said, yeah, I'm not saying that part. I was like, what? You can't not say that part. It was the part that the prosecution has to prove that the defendant is the person who committed the crime. He's like, I'm not going to say that part. It was the ID case. I was like, you can't. Yo, I tell y'all, the crazy shit that happens to me is amazing. And he didn't give the charge. He did not. He's like, I said that somewhere else. I was like, but you're supposed to say it here. Like, because we get a copy of the charge. You can read along with the judge. And it was like a whole block of text he left out. Like, he just gonna not read that part. Okay. And that's what happens when, the deck is stacked against you sometimes. Or when when a judge sees that you're winning as a defense attorney. Because they are pro-prosecution typically. And I've had that happen where even at the end of a trial, a judge will try to be an obstructionist, and we still won that trial. That was a murder trial too. But yeah. Keisha. Keisha said the girlfriend stated how she didn't like the guy. This is Maurice Hall that was with him because he kept giving him drugs, right? And the bad drugs, again, remember them funny pills, the pills that she said kept her up all night, made her feel jittery. right? So that's Maurice Hall. So his testimony, listen, if the prosecution doesn't call him, the defense will subpoena him, but the defense doesn't have the ability to give him immunity. And so they can't compel his testimony in the same way that a prosecutor can. So that'll be interesting to see what happens with that. The defense might, yeah, I don't know if they could even move for a missing witness charge, saying that you could have called this person. And the fact that you didn't call this person, the jury should infer that his testimony would have been damaging to your case. So I don't know if that will happen. I mean, remember, this is Minnesota. I don't practice in Minnesota. So we got 5 minutes left. You don't think they proved Derek killed George? Hell no. Golden God, no. I do not. Click the gear in the bottom center, go to green screen, move your. I know. I already know, Mikey. I talked about that already. My green screen ain't over. Y'all know what's behind there. My couch, my degrees. I'm covering up my sheepskins. It's all good. It's all good. You still love me, right? All right. So no, Golden God. I do not think that they have proved that Derek Chauvin killed George Floyd without a shadow of a doubt. Which they don't need to prove it beyond a shadow of a doubt. They only need to prove it beyond a reasonable doubt. And no, I don't think they have proved it yet. So we'll see. We'll see. Because you remember, each crimes have elements, and you have to prove each element beyond a reasonable doubt. One of those elements is causation. You have to prove that the actions caused the death. And there's science that is refuting what it is people think they saw. And so, in a court of law, it's not what you feel. It's not emotions, right? None of that is valid in court. In fact, the judge is going to instruct the jury that your decision has to be free from sympathy and bias. You can't feel bad for George Floyd and his family. We can't feel bad for the witnesses that came up here and cried, or the fact that they're living with the trauma of having witnessed this event. That can't factor into your decision making. We don't need another uprising like LA. Yeah, Daryl. I mean, I don't know. I don't know. I don't know what would happen. Honestly, I really don't know. G Mars, I want to be an Esquire like you. Go for it. Do you think Derek Chauvin would have been better served by a bench trial? Oh, that's a great question. Hell yeah. Hell yeah. Hell yeah, absolutely. And just a little background. I think I heard some background about Judge Cahill. He was appointed by Republican somebody, conservative. I'm sure he's pro-police. I'm sure if he was ever running for judge again, that there would be plenty of money from the police union to support him. It is not, I always recommend that a police officer go bench, because especially in this climate where we don't, where there is this this atmosphere of police distrust, I wouldn't chance it. I wouldn't chance it. No. Check your email. Okay, I will. I'll check my email after. I think I got a couple things on here. I think I could put. Ooh, Al, check me out. Check me out. Check you out. Yeah. And I can put that on here too. For those of you who want to help me out so I could get a bigger green screen. I need a green screen. I need a microphone. I think I need a new computer. Or at least I might need to buy memory for it. Or I need some kind of optimizer. But I'm working on it. I'm working on all of that. All right, family, we down to 1 minute. We down to 1 minute. The prosecution halfway through. When are they going to prove it? Right, Keisha? They're halfway through. I think they're a little more than halfway through, because they did the witnesses, the bystanders, and they're pretty much through use of force. That was all today. And even the judge was like, I don't know how many use of force cops you want to bring in here, but I'm not about to allow all of them to come in here and say the same thing. I mean, he didn't say it like that. I'm paraphrasing. I'm giving you Ike speak. He basically said, because it's cumulative. They all going to say the same thing. And at some point, cumulative testimony becomes prejudicial. It becomes prejudicial because people tend to believe it more if more people say it, right? Even though no matter how many times someone says something that's not true, doesn't make it true. It's human nature to believe that if someone, if you could get a number of people to come in here and say the same thing, then that is it's gonna have a little bit more weight, a little bit more credibility. So the judge is even like, yeah, I'm not doing that. So get your experts together, and these people can't give opinions about certain things because they are not experts. And I'm going to allow you to have just those two experts on use of force. I believe they were allowing two. And so after that, we've got the medical stuff, medical examiner for causation. And that's it. And that's it. So they haven't proven it to me yet. But again, the reprimand by the court always is, do not decide this case until all of the evidence is in. And so I give you that same reprimand and caution, is to not make any decisions on the evidence until it's all in. So we'll see. We'll see what happens tomorrow. Drop it. Get you money. So Cash App is going down at the bottom. It's Ike Speaks. I think that says it should say Ike Speaks. Let me make sure. It should be Ike Speaks, but I can't see stuff sometimes. But it's Ike Speaks. Same thing there with the $ that y'all see. I think I might have. I know I can't see. Hold on. Yeah, that's it. Yeah, that's it. That's just how the small I looks like a L to me, but it's a IKIE Speaks. So I appreciate y'all. Back to the comments. All right, so I'm going to try to get back on here a couple times during the week to catch us up. Thank you, Mikey. I do need it's pretty big. I didn't realize how much space was behind me. I might be able to just move it around a little bit. People start shaking and moving all around. All right, so I gotta go catch up. I missed verses last night. I heard it was good, so I gotta go catch up. All right, family. It's your girl Ike. I love you. Thank you for joining me. Thank you for your patience while I try to work out this new little platform with StreamYard. It'll get better. It will. So if you are not on YouTube, please subscribe to my YouTube channel. I guess I'm supposed to say like and subscribe and hit that notification bell, right? Because I'm trying to be a YouTuber too. All right, family. I love you. I really do. Y'all be good. Peace.